Good afternoon, Judge. I understand I'm the last one, maybe before lunch, so if your blood sugar is getting a little low, you can think about having a little break. But just because the chairman keeps bringing this topic up, let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Oh, Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding and in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them. It depends on the circumstances.
It depends on the circumstances.
Yes,
So you put this in the same category as defining what a biological woman is.
no, I'm
You're
just,
really not sure.
I didn't say I wasn't sure. I said it depends on the
So you
circumstances.
are sure.
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
I just don't think that's credible, Judge. Let me ask you another question. You talk about the public confidence in the courts, in our institutions, which I agree are very, very important, that the public has confidence in our judiciary. Would you agree with me that to the extent that people perceive that judges, unelected, lifetime tenured judges, are making policy pronouncements or political decisions, that it undermines public confidence?
I do.
Thank you. Yesterday, we talked a little bit about precedent. And I know Senator Feinstein, as she does in these hearings, talked about super precedent, and in particular, Roe versus Wade. And I want to talk a little bit about that. But first, let me just ask you, do you think there's any good reason for the Supreme Court not to overrule a previous decision when they've concluded that that decision was wrong?
Thank you, Senator. Again, it's hard for me to answer that question in the abstract. What I'll say is that the Supreme Court has laid out factors beyond just the precedent being wrong as a reason to overturn it.
Well, we talked a little bit about this yesterday. The Supreme Court revisited the issue of separate but equal, which was the law, the constitutional interpretation of the Supreme Court under Plessy versus Ferguson, and overruled that precedent because
Yes.
it concluded it was wrong, right?
I haven't looked carefully at whether all of the different factors that the Supreme Court now uses to overturn were discussed in the opinion. But now the Supreme Court's precedent is to overturn on the basis of a number of different factors and not just whether or not it's wrong.
So are you suggesting that the Supreme Court could not or would not overrule a precedent that it determined was wrongly decided?
No, I'm suggesting that the Supreme Court's case law indicates that it looks at multiple factors.
No, I understand. You go through the stare decisis analysis,
Yes.
right?
Yes.
But if it's wrong, that's one of the factors that you consider, right?
Yes, but it's not the only one.
So are you suggesting that there may be circumstances under which the court determines its previous decision is wrong, but it will not overrule it?
The fact that there are multiple factors indicates that the court looks at more than whether or not it's wrong.
Okay, so you would say, if I'm interpreting you correctly, that if the court concludes its previous decision is wrong, it won't necessarily overrule that. It applies a multi-point analysis.
Yes, I think that's
Okay.
accurate.
Back when Roe versus Wade was decided in 1973, generally speaking, the court said that the states may not limit access to abortion pre-viability, but post-viability, there could be some restriction on the right to abortion. Is that generally the,
As a general matter, yes.
okay, thank you, okay. Well, and then I think it's since 1973, the question of viability has risen again, what that actually means, because now viability was around 28 weeks. That is, the fetus could live outside the womb, but today, because of the advances in medical science, the fetus can live outside the womb after about 23 weeks. Is that your understanding?
Senator, I haven't studied this, so I don't know a number of weeks in the way that you're
Okay.
saying.
Well, let's talk a little bit about viability. The line that was drawn for pre-viability and post-viability analysis by the courts. What does viability mean when it comes to an unborn child, in your understanding?
Senator, I hesitate to speculate. I know that it is a point in time that the court has identified in terms of when the standards that apply to regulation of the right.
Justice Brennan, at a later point in his career on the Supreme Court, admitted that the viability line was an arbitrary line. Do you agree with him?
Senator, I'm not able to comment on viability. There's a case pending in the Supreme Court right now concerning the issues.
I'm asking you about previous decisions, but I hear you. No one suggests that a 20-week-old fetus can live independently outside the mother's womb. Do they?
I don't know.
I mean, the child will need to be fed or sheltered and all the other essentials to sustain human life. So there's no suggestion that after 20 weeks that a child can live independently, correct?
Senator, I'm not a biologist. I haven't studied this. I don't know.
You don't know
What-
whether an unborn child could live outside the womb at 20 weeks gestation?
What I know is that the Supreme Court has tests and standards that it's applied when it evaluates regulation of the right of a woman to terminate their pregnancy. They have the court has announced that there is a right to terminate up to the point of viability, subject to the framework in Roe and Casey, and there's a pending case right now that
Right.
is addressing these issues.
The Constitution doesn't mention the word abortion, correct?
That's correct.
Just like it doesn't mention the word marriage, correct?
That is correct.
And so as you and I discussed, perhaps ad nauseum yesterday, when we were talking about substantive due process, this is one of those unenumerated rights that the court has created, court-made doctrine or law, and creating a constitutional right, even though it's not explicitly mentioned in the Constitution itself. Correct?
The court has interpreted the due process clause of the 14th Amendment to include.
Right. We talked about substantive due process yesterday, and that's what this is, right? The Supreme Court cases that deal with the right of abortion is a result of substantive due process analysis like you and I talked about yesterday.
Yes.
Okay. In the, you remember when you were confirmed for the Court of Appeals, in that process, we had a hearing, and then we sent you questions for the record, what we call QFRs around here.
Yes.
And one of those, question number 10, was, does the Constitution protect rights that are not expressly enumerated in the Constitution? As part of your answer, you mentioned Roe versus Wade and Planned Parenthood versus Casey, and you said this, and I'll quote, they articulate a limited right to terminate a pregnancy. What is the limitation that you understand that was pronounced in Roe versus Wade and Casey when it comes to a right to terminate an abortion? What are the limitations under current law?
Under current law, as I understand it, there are limitations in so far as there can be regulation of that right pre-viability unless the regulation imposes an undue burden on the exercise of the right. And there can be regulation after viability, as long as there's exception for the health and I think maybe life of the mother. So it's the limitations are about whether and to what extent the government can regulate the right.
Is it your understanding under the current precedent of the Supreme Court that there is a right to abortion up to and including the time of delivery of the child?
Senator, I don't know, actually. I mean, the Supreme Court in every case is looking at individual regulations of the government related to individual rights. And I am not aware of the court having made a pronouncement about whether or not regulation can extend all the way up until birth. I'm just not aware of that. And that it's because the court is looking at individual cases and making its rulings in the context of individual cases and not making sort of pronouncements in general.
So you are suggesting that in some individual case, the right to abortion could extend through the entire pregnancy up until the time the child is delivered?
No, Senator, I'm suggesting that I'm not aware of any case that's handled the issue.
You told us that you think that you believe Roe versus Wade and Casey are precedents, and we talked a little bit about some of the questions about whether it's a super precedent and the like. Are you familiar with the Supreme Court's decision in the Heller case?
I am.
And that was a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment, correct?
Yes,
Is that a precedent of the court?
it is.
And you would respect that precedent?
Yes, Senator. All precedents of the Supreme Court have to be respected.
Is it equivalent in terms of its precedence to Roe versus Wade, or would you evaluate it differently?
I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis.
I agree with you. That's why it kind of blows my mind when people talk about super precedents, as if somehow one precedent was different in terms of its significance or priority under the Constitution than others. In the short period of time I have remaining, let me just revisit with you some of the questions we talked about yesterday with regard to free exercise of religion. And of course, that's recognized explicitly under the United States Constitution, the First Amendment, correct?
Yes.
Okay. Are you familiar with the cases that have been litigated before the Supreme Court of the United States involving the Little Sisters of the Poor with regard to the Affordable Care Act mandate on contraception coverage?
Yes.
Now, the Little Sisters of the Poor, a benevolent group of nuns, I think there are about 300 of them that take care of elderly and infirm individuals. And of course, as a matter of their religious beliefs, as documented in the court's opinions, they don't believe in either contraception or abortion. Do you agree with that?
I believe that was described in the case that you're talking about.
I think that's right, too.
Yes.
Yeah. And so when the Affordable Care Act mandated that every health insurance policy contain coverage for contraception or chemically induced abortions, they objected and said that this violated their conscience and their free exercise of religion rights under the First Amendment, right?
I believe so, yes.
Well, after the Obama administration, during the Trump administration expanded the regulations to allow not only churches, but also religious organizations like the Little Sisters of the Poor, a waiver from that contraception and an abortion-inducing drug mandate. Do you recall that?
Yes.
Are you familiar with the fact that President Biden has said he would restore the previous regulation and that was promulgated under the Obama administration and exclude organizations like the Little Sisters of the Poor from that waiver potential for abortion drugs or contraception coverage?
I am not aware of that, Senator.
Well, I guess what all this boils down to, Congress passed a bill called the Religious Freedom Restoration Act, which tried to make sure that people's sincerely held religious beliefs could be accommodated under their First Amendment rights, as opposed to Congress mandating things that would violate their conscience and violate their religious beliefs. Do you agree with me that it's important to accommodate the sincerely held religious beliefs of all Americans when it comes to legislation that the Congress may pass?
Thank you, Senator. Religious freedom is a core foundational constitutional right. It's in the First Amendment of the Constitution and reflects the Founding Fathers' understanding of this country as being one that is based on, in large part, the idea of pluralism, the idea that people can come and have sincerely held religious beliefs and practice them without persecution. That's part of the foundation of our government and the amendment that you're discussing. And as a result, that right is protected in many ways. You mentioned the Religious Freedom Restoration Act.
Right.
Congress has enacted a statute that, when it comes to federal regulation, if there's a substantial burden placed on religion, then the strict scrutiny standard applies.
I agree. I have 1 minute, so I have one more
Yes.
question. I agree with what you just said.
Yes.
So since I have asked this question or made this point of some of your predecessors who sat in the same chair and expressed my concern about some of the court's establishment law, establishment jurisprudence, I don't want to leave you out of that concern. When I was Attorney General of Texas, I had a chance to argue a case in front of the United States Supreme Court and called Santa Fe Independent School District versus Doe. This was a lawsuit brought by the ACLU, which sought to enjoin or prevent a student-led prayer before football games at the Santa Fe Independent School District right outside of Houston. In the end, 5 judges said that that violated the Establishment Clause of the Constitution, causing Chief Justice Rehnquist to write in his dissent that the Constitution mandates neutrality toward religion, not hostility, but that the court's decision evidenced hostility towards religious expression, leaving me to conclude that the public square, we can talk about everything from violence to misogyny to sex, you name it, but we can't talk about sincerely held religious beliefs. I would just footnote that for you and plant the seed for what it's worth. Thank you very much.
Thank you.
Thank you, Senator Cornyn.